Hey everyone, my name is Nicole Gaither, and I'm the owner of Creativa IP Law, a law firm that focuses on trademark and copyright registration. I am putting together this video because I sometimes get questions from people who are in the beginning stages of setting up their business or they're already in business and they want to understand the process behind filing for a federal trademark registration. So I am going to start kind of from the beginning. So a trademark is a word. It could be your business name or a product name, service name. It could be a symbol or a logo. Think of the Nike swoosh. Or it could be a tagline or slogan. Think of just do it. That is a source identifier for your goods and services. It's how your customers can, pick out your goods and services and not pick out your competitors because you all have different identifiers of your goods and services. So that is what a trademark is. And once you start using those things in connection with your goods and services, you have a trademark. And you also have protection. It's called common law protection, but it is limited just to the geographical area where you're selling your goods and services. So you would only be protected like in your state, but not nationwide. So if someone else had the exact same trademark and they're using them for related goods and services and they were in a different state, then you can't stop them from doing it because they have the rights in their state and you have the rights in your state. The only way you would be able to stop them from doing that is if you file for federal trademark registration through the USPTO. And so that's what we're going to talk about today. So if you have a mark that you're using in relation to your goods and services, and you are already selling goods and services, or you're thinking about selling goods and services, then you might want to consider federal trademark registration, especially if you have customers who are in other states. So a trademark is, like I said, a source identifier for your goods and services that are being sold in interstate commerce. So that means in states outside of yours. So you have to have more than one state involved for you to be able to register a federal trademark for a federal trademark. Okay, so now that we've gotten through that, so this next step would be, we would look at the name that you selected, make sure it's a name that can be protected through the federal trademark registration process, that it has strong protection. It's one that is not very similar to a famous mark, that it's not generic, that it's just not like, bike for bike company, that it's not just a surname because that will give you very limited protection. So we're going to be focusing on making sure that your mark, and we're going to work with you on this if we need to, is one that is either a made up name, it's one that's arbitrary, kind of like think of Apple computers, so Apple fruit, Apple computers, or it's one that is suggestive. So my favorite example is Snuggle fabric softener. So once we've determined that you have a name that can be, that gives you very strong protection, or, if you do want to continue with the registration of one that is considered a descriptive mark, I just want to, I will caution you on the fact that you might not get the registration that you're looking for, or you might be limited by just registration. But you will be told that in the beginning because I have no reason to not tell you that, because I'm not trying to keep your money and take your money for something that's not going to get move forward. Like my goal is to have a nice little R next to your trademark. So once we've determined that you have something that can be used, the next step is for us to do what's called a knockout search. That's where we go to the USPTO's website and look at their database of marks to see if anyone else has a mark that is exactly like yours. And if we do find one, it does not necessarily mean that you can't use your mark. It just means that we need to look and see what that person is using the mark for. And if it's for goods and services that are just like yours, then we, again, like I said, probably need to go back to the drawing board and pick out a different mark or find a different way. Maybe we can work with that person. See, these are options that might be available, but it really just all depends. And again, it's beyond the scope of this video. So let's say that we did not find your mark in the Federal Trademark Registration database, or if we did find a mark, it wasn't one that is using your goods and services. So we would also do like a Google search, just kind of looking at to see if there are any other companies that might not have federal registration but have a similar mark to yours. If all those things check out and we see that you are good to go, then this is the stage where an attorney, is really good to have, we would do what's called a clearance search, and it would be a comprehensive clearance search where we pull a third-party vendor report using the mark that you plan on registering, and we pull it in connection to the goods and services that you plan on registering it with, and also related goods and services. So what we're doing is we're looking for marks that would be confusingly similar to your mark. So it could be something that is, starting with the same couple of words or involve the same words as yours, or they're spelled differently. They might sound the same, but they have different, spellings, or it might be pronounced different, but it looks the same. All of these are going to be involved in this comprehensive clearance search. And this is because the trademark office looks for marks that are confusingly similar to other marks, because the goal is to make sure that customers are not confused when they're picking out goods and services, that they don't have to sit there and wonder if this is a shampoo that was made by the shampoo maker that they always use, or if it's the competitor shampoo. And then they're sitting there like, I can't figure out which one is which. So that is the goal of a trademark, and that is the goal of the trademark office when they're doing a registration and looking at your application, is to make sure that there's nothing confusingly similar with it. So once an attorney has pulled this report, looked at the results, done an analysis, most attorneys will do what's called an opinion of the analysis, and they'll issue a letter telling you like what their search, what the search report found, the ones that we need to be aware of that might cause problems with your registration, and they also give you an opinion as to whether you should move forward with registration, or what the likelihood is if you might be getting an office action. Again, there's no guarantee in the process, so like we cannot guarantee that you will get a registration. The goal is to get a registration, and these are things that we do so that we can get to that process and get through that process without any other hurdles that we might not be aware of. At least at this stage, we probably would know what might come at us during the stage, the process of registering for your trademark. So once we've gotten that opinion and we've determined that it's good to go for you to register your trademark, then we will start drafting the application. And we will make sure that, we have to make sure that the ownership of the trademark is correct. So if it's either owned by you or owned by your business, then we need to put that down on the application. If you are registering as an individual, I'm going to make this note. If you, get a PO box, because your address is going to be a part of the public record. So if you don't want your address as a part of public record, get a PO box, or, making sure that your address is not the one that's going to appear on the application. So get something that doesn't have your home address. That's not going to be public record. So that's my little caveat, my little tip. So once you have the ownership, making sure that you have the dates that you use the mark, dates that you first started using the mark, and the dates that you started using it in interstate commerce, which means, states outside of yours. Also, we need to give a description of the goods and services, and there are 45 classes of goods and services. And within those 45 classes, there are even more detailed descriptions. So we want to make sure that we properly describe your goods and services, because if we don't properly describe them, then you wouldn't be protected very thoroughly. And then you might also get an office action, because the trademark office might determine that you didn't do a very thorough description. So they might ask you to provide more information. We're also going to submit what's called a specimen. And this is evidence of you using the mark. So this would be like a hang tag for your shirts that has your mark on it, or it might be the label at the back of your shirt, or it could be a brochure advertising new goods and services. Also, it could be from your website with the goods and services that are available for sale. So, and then also like the shopping cart that shows where people can make purchases from your website. So these are, of course, if you are already in business. If you are not in business but are reserving a name, we would file what's called an intent to use application, which means that we're reserving your name, and then we will get to the stage where when you start selling goods and services, then we're going to submit that information to the trademark office once they let us know it's time. So once we've gotten all the things that need to be put in the application, we will pay for the fees, and you are charged a fee per class. So like if you have you're selling apparel and you're selling candles and you're selling other things, then those are in different classes. So a fee needs to be paid for those different classes. Once we paid the fees, once we submitted the application, then the application is accepted by the trademark office, but we are then put in a kind of a holding pattern for 3 months. So that means like 3 months, it's just kind of there. It's been, the trademark office received it, but now it has to be assigned to an examiner. And once the examiner gets it, then the examiner will make sure that it was completed properly, and they'll start doing their work on it. So they want to make sure that there's not any other mark that's similar to yours, that's either registered or pending. They also will look at to make sure that it's a mark that can be registered, so it's going to something that has the scope of protection that is going to be necessary for it. And they also will look at the description of goods and services, the evidence that you submitted for the use, all these things. So if they have a problem with that, they'll issue what's called an office action, and so that's something that needs to be responded to within 6 months. Don't wait to respond to that. And usually, again, this is when an attorney is good to have, because an attorney can answer quickly because they have the level of experience to do that. If there are no issues with your application and you move through the process, then the next step would be, if you've already submitted all of the evidence and you're already your name is already in use, then you would move through hopefully through the process to getting a registration. If you were reserving your name, like that intent to use application, then there will be a point where they'll let us know that we need to submit evidence of the mark in use. So we would file what's called a statement of use, submit the evidence showing that you're using the mark. If you're not at that stage yet, we can ask for an extension, and that gives us an additional 6 months for you to get everything together. Or if you need more extensions, and we're limited to 5 extensions. So think of that, 6 months times 5, you have like 30 months. So, that's 2.5 years. So, you do want to start getting something done in that time frame. So, 2.5 years of extensions, but you technically would have like 3 years because you were given the first one 6 months. Okay, so yeah. But anyway, so getting through this video, just so hopefully you all understand the process at this point. So again, there are some steps that are involved with getting you to federal registration. Like I said, you don't have to have an attorney involved, but it's always a good idea. And especially, it's good to talk to an attorney to make sure that you have a mark that can be registered. And if it's something, that making sure that it can be registered based on the name and the selection of the mark that you're using, and also making sure that nobody else is using it. So I hope that you all got some information out of this video. If you have any questions, please feel free to give me a call at 504-294-4295, or you can hit me up on social media. I'm on Instagram and Facebook and Twitter. You can go to my website and send me a message, or you can email me. So thank you, and I look forward to talking to you all soon about